Before I turn it over to Jay, I do want to take a moment to introduce two new faces here at the League. We have Matthew Hares starting with us as our new events coordinator. Matthew will oversee all events at Credit Union House, as well as handle all logistics for offsite League training and events. We also have JT Blau here this morning. JT is our new Chief Advocacy Officer and will play a key role as part of our advocacy team here with our president, Carrie Hunt, who I believe is also on the line here today. So today we are pleased to have Jay Spruill with us from Woods Rogers. Jay is a member of the firm's banking and financial services group and works from their office here in Richmond. Jay currently serves as lead attorney for the League Compliance Hotline. So Jay, I will turn it over to you.
Well, thank you, Mary. Good morning, everyone. It's a pleasure to be with you. I hope everyone's having a good summer. This compliance roundtable, as we do with each such event, I've selected some recent developments and issues that have come to fore that I think might be helpful to go over with you all. I think we can draw some lessons from these developments and some things for you all to think about as you go about your job and ensuring that your credit union complies with the laws and regulations that you have to attend to. As Mary said, I welcome any comments or questions during the presentation. If you have a question, I'm sure other people might have a similar or same question, so please do not hesitate to ask. So the first topic that I chose to talk about today is elder financial exploitation, or sometimes referred to as elder financial abuse. This is a growing problem that is increasingly getting the attention of government agencies and legislative bodies. Just a month or so ago, the Department of Treasury's Financial Crimes Enforcement Network, otherwise known as FinCEN, released a report. And in that report, they said that 10% of the elderly adult population are affected each year by financial exploitation, which was really a surprise to me. That's a big number. 10% of the elderly population each year are affected by some form of financial exploitation. The majority of these incidents go unreported. The pandemic exacerbated the problem, and year over year it seems to be increasing. There were 72,000 suspicious activity reports to FinCEN last year involving elder financial exploitation. So it's a problem and it's growing. Many of your members are elderly, and I know that the credit union wants to do what it can for all its members, and maybe particularly your elderly members. So it's something to think about. And what I wanted to go over this morning is, what can you do? What are you required to do? And what may you do in efforts to try to protect the elderly who are your members? This session, the 2022 Virginia General Assembly session, there was legislation enacted that enhanced what financial institutions have to do and what they may do. And I just wanted to go over that, and then I'll go over existing law so you can get a sense of what's changed, what you can do, and how you can help your members. So legislation this year, for the first time, requires a financial institution to cooperate with a local Department of Social Services that might be investigating suspected elder financial exploitation or financial abuse. Importantly, it requires a financial institution to turn over records and information to that local Department of Social Services if the department requested. So I know on the hotline, there have been instances in the past where I've been asked, well, we've got this letter from someone at the local Department of Social Services. They want this information. Can I turn it over? Well, we didn't have a law that authorized that. So often the answer was no, you do not turn it over. Well, that's changed. Now, if you get a request from the local Department of Social Services, you do have to make information, financial records on your member available to that department. Under this legislation, a financial institution, a credit union may voluntarily, so this is not something you have to do, but you may do, you may voluntarily report suspected financial abuse to the local Department of Social Services if you have a good faith belief that there is in fact some financial exploitation taking place. And I want to point out this one thing in the legislation, and all of what I've talked about, this, what you're required to do, actually went into Title 6.2 of the Code of Virginia, which governs financial institutions. There's another title that deals with local Department of Social Services and reporting. But this legislation, requiring cooperation with the local Department of Social Services went in the Financial Institutions Code. The legislation does say, to the extent permitted under the Gramm-Leach-Bliley Act, privacy provisions. And so, you have to comply with the law if it's consistent with GLBA. Well, I looked at the Gramm-Leach-Bliley Act privacy provisions, and there's a number of exceptions to the general rule that you don't disclose. One is to protect against or prevent actual fraud, unauthorized transactions, or other liability, to comply with federal, state, or local laws, and to comply with a properly authorized civil, criminal, or regulatory investigation. So in my opinion, disclosure is permitted under our state law, under the Gramm-Leach-Bliley Act. Now, a very important point. If you disclose, the legislation statute says that absent gross negligence or willful misconduct, a financial institution shall be protected from civil or criminal liability. That's what we're always concerned about when we're asked to share information with a third party on a member's account. But this legislation protects a credit union from any potential liability if it acts in accordance with the legislation as I've just described. There was a couple of other bills I'll just mention on this dealing with elder financial exploitation. One, a bill changed the definition of an incapacitated adult to vulnerable adult. So this nomenclature, you might hear vulnerable adult now instead of incapacitated adult when we're talking about the law. There was also legislation addressing powers of attorney, and when the situation where an agent knowingly and intentionally engages in financial exploitation of an elderly adult, and that legislation says that's a class 1 misdemeanor. And most importantly, if there is a conviction for that, the agent's authority to act under the power of attorney is revoked. So that's just by operation of law. The important point here for you all is that if you have knowledge that an agent has been convicted in connection with his use of the power of attorney for an elderly person, you should no longer honor that agent's authority. Now, I want to talk finally about existing law. This is has been in the law, and it's still the law today. A financial institution, a credit union, may refuse to execute a transaction if it has reason to believe that there's financial exploitation. There has to be a good faith belief, but the law allows a credit union to refuse to, say, allows someone acting under a power of attorney to withdraw money if there's a suspicion, good faith, that that person is financially is engaged in financial exploitation. Also, if you make a report to the local Department of Social Services under the law, or know that another person has, you can refuse to engage in the transaction. And obviously, I think if you report to the Department of Social Services, you should refuse to do so. Now, the important point is you may refuse to execute that transaction, allow, say, in our example, the agent under a power of attorney to withdraw funds for up to 30 days, but no longer than that, unless you get receive a court order that says otherwise. Court, the agent might go to court, say, no, there's no problem. It's a court order, and then you would have to release those funds. And so that's kind of important. It just lasts 30 days. That's all I'm going to say about financial exploitation. I just think it's going to continue to be a big issue, one that we should pay attention to. It's something that your credit union might want to develop some policy on and incorporate these principles, these rules under Virginia law, not just to comply with the law, but to best serve your members. Second topic I want to take up is the Equal Credit Opportunity Act and an advisory opinion that the Consumer Financial Protection Bureau recently issued. Regulators often issue advisory opinions, supervisory alerts, what have you, when they see that there's a great deal of non-compliance with a particular issue. And so the CFPB issued this advisory opinion because they see creditors that are not aware or not complying with the application of the Equal Credit Opportunity Act and Regulation B to existing customers. And this advisory opinion affirms that ECOA and Reg B apply not just to those seeking credit, but also those who have received credit. So those would be your members or that have received a loan, credit card, open-end loan. I think the definitions are important in Reg B in this regard. They're in your outline. I just wanted to go over them real quickly because it will kind of emphasize how Reg B does apply to existing customers or members. The definition of applicant includes any person who requests or who has received an extension of credit from the creditor. An existing account holder refers to an applicant who has applied for and received an extension of credit. Existing account or existing credit arrangement refers to an extension of credit previously made by a creditor other than an extension of credit that is closed or inactive. And importantly, adverse action includes a termination of an account or an unfavorable change in an account that does not affect all or substantially all of the class of creditors' accounts. So what does all this mean, and what has the law always said, but the CFPB is saying, creditors, you need to do a better job on this. It means that if you have an existing credit account for a member, you have to give an adverse notice adverse action notice if you make an unfavorable change, terminate an account, or make a change that doesn't affect all or substantially all your members. So some examples are, suppose you decide to just terminate a member's credit card account. Well, that would be a termination of an account under Reg B, and you would have to give an adverse action notice. Suppose you have a member who requests that the credit limit on an open-end line of credit be increased. If that's denied, that triggers the need for an adverse action notice. So it's something to think about, and I really want to emphasize under the Equal Credit Opportunity Act, there is a private right of action, which means the law gives consumers the right to sue for non-compliance, and they can get attorney's fees and costs of pursuing that. There's class action liability, potential liability. So this is something important to pay attention to. It certainly was something I don't think about a lot, so that made me think that maybe it would be worthwhile to pass it along to you all. So the third thing I'm going to talk about this morning is a CFPB consent order with Bank of America, in which Bank of America was forced to pay $10 million based on how they handled garnishments that they received, garnishments directed to their depositors that were issued by courts across the country. And as big as Bank of America is, you can imagine, in the consent order notes this, they received thousands of these garnishments. And when they received the garnishments from a particular state court, they would process the garnishment under that state court's law. So if a North Carolina court issued a garnishment, Bank of America would respond based on what North Carolina law said. Well, the CFPB came after Bank of America because the bank should not have been, in many instances, applying the law of the state that issued the garnishment, but rather the state where the customer, Bank of America customer whose account was being garnished, resided. And that's kind of the rule. So if a North Carolina court issues a garnishment that was going to garnish the account of a Bank of America customer who lives in South Carolina, North Carolina law is not supposed to apply. It's supposed to be South Carolina, and the reason for that is the law of where the consumer resides has particular protections from creditor process, exemptions, and those laws apply, not the law of the issuing state. Of course, a lot of times the law of the issuing state, or the issuing state, is going to be the same state where the consumer resides, but not in all instances. And in this case, Bank of America was processing all these garnishments under this kind of a black and white rule. We're going to look to the law of the state court issuing the garnishment, and not the law of where our customer resides, and that was wrong. And Bank of America was forced to pay $10 million, and obviously a great deal of embarrassment. I'll also note in this consent order that the CFPB noted that the Bank of America had in its deposit agreement that customers waived any liability, the bank's liability for any garnishment protections. In other words, you had your account agreement and says, listen to the customer, we, the bank, are not going to be liable for anything in connection with how we process garnishments. The bank also, I think, depositors or customers might call the bank, and then the bank would say that the customer could not go to court to prevent a wrongful garnishment. And all of this, at the end of the day, the CFPB found that Bank of America had engaged in unfair and deceptive acts and practices, and again was held liable for $10 million. What are the lessons from this for credit unions? So I know, credit unions receive garnishments, other creditor process. The lessons are really, one, ensure that when you receive a garnishment or creditor process, that court has jurisdiction over the credit union. If you, for example, a credit union that's just operating in Virginia receives a Texas garnishment, the Texas court does not have jurisdiction over the credit union, and you should not honor that garnishment. It would be up to the creditor to come to Virginia, domesticate judgment or whatever, and get the garnishment issued by a Virginia court. And that wasn't so much of an issue in the Bank of America case, because Bank of America is in practically all the states. But it's just something that I wanted to bring up in connection with this as you think about how your procedures for managing garnishments and so forth. So let's assume that the court does have jurisdiction. This consent order, obviously, you need to check and make sure that the court, the state where the court is located and issuing the garnishment, is the same state where your customer resides or your member resides. If you receive a Virginia garnishment and your member resides in North Carolina, the member's residence, North Carolina law will apply, not Virginia law. And that law might provide exemptions and other protections that Virginia does not. And so you would respond to the Virginia court that, that our depositor is a resident of North Carolina and we cannot comply. And then it would be up to the creditor again to go to North Carolina to domesticate that judgment, take action to get the garnishment issued under North Carolina law. Another lesson from this is kind of obvious. As a lawyer, I know that we always want to put a lot in deposit agreements, account agreements to protect the credit union, bank, whoever the financial institution is. But this consent order makes clear that if you put in waivers or limitations on liability that are not permitted by the law, that will be deemed a misrepresentation. And so we need to avoid that. I know many of you use software vendors for your account agreements, and hopefully they're, and I'm sure they are on top of that, because we cannot put things in customer member agreements that are contrary to what the law says. And also the last point I'll make is avoid making misrepresentations about the law. Bank of America, people would call, and I guess they call a certain place in the operations of the bank that handled garnishments and other creditor process. And it appears that they just had a practice of telling depositors, well, you can't do anything about this. And that was incorrect. And that was deemed a misrepresentation by the CFPB. So don't misrepresent the law in terms of the rights of your members or the rights of the credit union. So moving on to the next topic I wanted to take up.
Hey, Jay,
Yes,
can I just ask a quick question for you before we move on?
yes.
So a lot of our credit unions receive other types of, legal orders. Child support orders is one that they get a lot. Would the same jurisdiction rules apply? Say a credit union received an out-of-state child support order. Would the same, ensure a court has jurisdiction before recognizing? Would that be the same advice to apply for those types of orders, or is that something just specific to garnishments?
Well, that's an excellent question, JT. I'm glad you asked it. The same principles would apply. The same rules would apply. Does that court issuing the child support order have jurisdiction? Is the question. And if not, then the credit union should not honor it. And I'd say that's also the same for subpoenas, any kind of court orders or what have you. You don't respond unless there is jurisdiction. So I wanted to talk about a recent Virginia Supreme Court case. It's always interesting to kind of analyze the facts of cases where they involve financial institutions, accounts, and loans, and kind of see if we take some lessons from them in our practices. And there was a recent case, Stahl versus Still, and it deals with check collection and POD payee rights. I'm going to tell you the facts of the case. There was this elderly aunt. I'm going to call her aunt because a niece is going to come into play shortly. And she had bank accounts at BB&T and at MCNB Bank and Trust. She was elderly, lived with her niece, and received hospice care. The niece was a POD payee on the BB&T account. So that should trigger something in your mind right there. She was the POD payee on the BB&T account. Her aunt's living with her. And then what we learn in the case is, with the help of the niece, the aunt issued an electronic request to have $245,000 transferred from her MCNB account to the BB&T account, where the niece was a POD payee. So in this process, a check was generated and presented to MCNB, where the money was, but MCNB refused to pay that check for $245,000. I'm not certain. The case is not clear on how that practically worked out, but anyway, it was essentially an order for MCNB to pay the $245,000 to BB&T. I think the BB&T account was the payee on the check. Well, MCNB, as I said, did not honor that check, but they failed to return the check before its midnight deadline. Under the check collection rules, a bank has until midnight on the day following the bank day they received a check to return it. And in this case, MCNB did not do that. Subsequently, the aunt died. The aunt died. And just as it's not as important for the ruling, but during all this, the aunt's sister and another niece learned of this transaction and called MCNB and says, do not honor that. There's fraud involved. And I think later the check was presented again after the aunt had died, and again MCNB refused to honor the check. So the niece, who remembers the POD payee, and after the aunt died, she would have become the owner of that account. She sued MCNB based on its late return of the check before the aunt had died. And the Virginia Supreme Court held that the niece did not have standing to bring the suit. Standing is a legal concept, the right to sue. She did not have the right to sue. And she didn't have the right to sue because she had no interest in the account at the time the check was presented, because she was merely a POD payee. She was not the owner of the account. So the lessons from this case, and I know you all are aware of some of this, but it's always helpful to go over it because it comes up all the time. POD payees have no rights to the account in which they're named as POD payee until the account owner's death, because the account owner can change the POD payee, can remove the POD payee. So the POD payee has no rights. And therefore, the credit union should never honor a POD payee's instructions with regard to an account before the account owner's death. Now, once the account owner dies, that account passes by operation of law to the POD payee, and the POD payee can give instructions. But until that point, the POD has no rights. And lastly, I just always want to emphasize this because I see it so much in the questions we get on the hotline. Really pay attention to beneficiary designations, POD trust, Totten trust beneficiary designations, or survivorship rights when you're handling signature cards. You know, I like to think of it this way. If someone came in and said, I'm going to do a will, let's sit down together and write this will, I'm sure, let's assume for this point that a credit union official would be authorized to help with that. There would be a lot of care going into that. Well, you know, when someone, your member, designates a person to receive the money in an account, that's like a will. It's avoiding probate, but it's a will, and often a lot of money can be involved, as in this case at hand, $250,000. So it's really important to pay attention to encourage your people to pay attention to how this is done, document thoroughly. Often see it come up where you have an account holder who's established an account, a member established account, might have joint with survivorship, POD payee, and they might come in a few years later and make a change. That process of making a change, sometimes not all the boxes are checked, and it's confusing what the member intended, because the member is dead, has died, and you've got to decide, where does this money go? So it can save the credit union a lot of time and a lot of potential liability by taking care to get all that executed the right way. The last thing topic I'll take up is just other legislation of interest to credit unions that was enacted in the 2022 Virginia General Assembly. And the first bill I want to tell you about and just sing the praises of your association. The Virginia Credit Union League did a great job in getting this bill passed, and it's just such a great bill. This bill provides that a state chartered credit union will have the power to engage in any activity, service, or practice that is authorized for a federally chartered credit union, and that has not otherwise been authorized before for state chartered credit union. So it's a parity bill that gives state credit unions the ability to engage in a activity, service, or practice. And I love the language there that, you know, the league chose to put in. That's very broad: any activity, any service, any practice. So if you're a state chartered credit union and you see that want to do something, it's not just the what the code says state credit unions can do expressly, but you ought to consider whether it's something that federal credit unions can do and make use of this authority. Now, it does come with some conditions. Notice must be given 45 days in advance. The Bureau would have the ability to say you can't do that. Hopefully they won't do that. They won't say no. And the activity, service, or practice that would be authorized for the state chartered credit union under this parity provision would be subject to the same terms and conditions that apply to a federally chartered credit union engaging in that activity, service, or practice. But a very positive bill. I think it will prove very helpful to state chartered credit unions. And again, kudos to the Credit Union League on getting this enacted. And I just got a note from someone, and I'm glad I did, because I wanted to, this is worth mentioning, that the league right now is working with the Bureau on regulations to implement this and to help credit unions with the best use this legislation. The next bill is House Bill 268, Senate Bill 326, priority of shares. I'm going to have to plead ignorance here and hope maybe JT can say something. The bill removes a provision that shares of members are subordinate to all other obligations of the credit union. I know this bill was put in for the purpose of allowing credit unions to issue subordinated debt, which is a good thing. I know that one credit union I've dealt with had to change their bylaws because of this. So an important bill, good bill, and something to look at.
Hey Jay, this is Carrie. I'll just jump in here. This was a technical correction that was required because the National Credit Union Administration changed their rules regarding subordinated debt, and it had a trickle-down effect. So we were happy to get this taken care of so that credit unions can still go ahead and issue subordinated debt, and not just low-income designated. With the conjunction with the parity bill, all credit unions should be able to issue subordinated debt under NCUA's rules and regulations. So we were happy to get this done as well.
Great, thank you, Carrie. That's a good explanation. You had a lot more than I knew about this. So
I don't think anyone wants to know the background of all the ins and outs on this one. This subordinated debt is very technical, and this is one of those unintended consequences that sometimes happen when laws get changed. So happy to help with the fix.
Great job on fixing it. Third bill I want to mention, this bill applies to banks, but I know it's something that the league is looking at for credit unions. House Bill 263 permits a bank to provide its customers with virtual currency custody services in a fiduciary or non-fiduciary capacity. Today, I guess we're thinking, who the heck wants to deal with virtual currency? It's all been declined in value so much, but I suspect it's possible it's going to come back, and this is something that's particularly with the younger generation and a lot of business savvy people, wealthy people, owning Bitcoin and other virtual currency is becoming increasingly popular. So I wanted to mention this bill because I know you're in talking with Carrie and JT that this is something that your league will look at in terms of helping credit unions have similar authority. The final bill I'll mention is House Bill 1153 and Senate Bill 303. By the way, when I mention two bills, they do the same thing. They're just identical bills introduced in different, one introduced in the Senate, one introduced in the House of Delegates. This deals with mortgage brokers and dual compensation, and I wanted to include it because I'm fairly certain that at least that there are credit unions that do have a real estate subsidiary, and so I thought it's something worth mentioning. This removes the prohibition on dual compensation for someone serving as a real estate broker and a mortgage broker in the same transaction. The law had been you can't receive this dual compensation if you're a real estate agent doing so. You can't receive compensation also for placing the mortgage. Well, this bill removes that, so one individual can receive a fee for acting as real estate broker and another fee for acting as mortgage broker, as long as a disclosure is given to the borrower about this, about how the person is being compensated. So that could be helpful to those credit unions that have a real estate subsidiary. So that's all I have, and I certainly would open it up. Any questions, comments that you may have?
Thanks, Jay. Any questions or comments for Jay? We have about 15 minutes.
And I'd also add, for future compliance roundtables, would appreciate any suggestions, any areas where you think that it would be good to discuss from a regulatory perspective or legal. That would be helpful. I'm always trying to think. There are a lot of developments and a lot of things that I don't think affect you as much. I try to pick ones the most relevant, but
Jay, would you mind talking for a few minutes about legal risk in general and some of the trends you're seeing coming down? We've had a lot of class actions on overdraft. We've seen, Wells Fargo and Navy Federal are being sued over Zelle. What are you seeing on the horizon with what credit unions need to look out for litigation risk?
Well, I think that you have a much more active CFPB in terms of protecting consumers, and new rules that will be coming out that are coming out that are consumer friendly, and that of course is, they change with administrations. The CFPB was not as active under the Trump administration in terms of coming out with new rules, and I think we'll continue to see that. Overdrafts, obviously that's a big issue. You mentioned Wells Fargo. I think that I'm hearing a lot of financial institutions, banks, and credit unions reducing or eliminating overdraft fees. I think it's not just the legal risk, but the reputational risk. It's something that's just got a lot of attention, and so financial institutions are reconsidering that and going in a consumer-friendly way.
I'll say on that too, I thought it was really interesting. CUNA recently met with CFPB Director Rohit Chopra, and he actually indicated he was less concerned about overdraft and happy with the way the market was going in that, because you are getting a service in exchange for the overdraft fee, he actually was concerned about NSF fees. So it certainly seems that the CFPB is playing, whack-a-mole with fees. And I will just say here at the league, we are continuing to work on changing the dialogue about fees. You can't, it does not necessarily make good business sense or benefit the membership to build everything into the cost of credit. And I think that is what the CFPB would love, that, there's zero fees and every single thing is built into a loan or just a pure account of fee. And I'm not so sure that benefits consumers. So we'll have to all work together to change the dialogue on that one.
Yeah, good point. So those are kind of my thoughts in response to your question, Carrie, and that's a good point you make. Follow up.
Any questions? Well, not hearing any. So thank you all again for your time today. And thank you, Jay, for your time as well. We appreciate it. I will be sending the slide deck that was shared today along with Jay's outline and the recording here. We'll also post a recap on vacul.org. So be on the lookout for that. As always, don't hesitate to reach out to staff at the league for any assistance. We're always here for you, and you can always reach Jay directly on the league compliance hotline. Thanks again, everyone. Take care. Have a great rest of the week.